What is a caveat? Under what circumstances a caveat can be filed, and what is the purpose of filing a caveat petition? Section 148A of Civil Procedure Code deals with caveat. When a person or a group of persons, a company, partnership firm, or say any legal entity which can be sued is suspecting or expecting or anticipating an application against them, and also there is an apprehension, there is a doubt, there is a possibility that the applicant is likely to obtain an ex parte order against them, which is going to damage, which is going to disturb the rights, which is going to challenge the legal rights of the person or a company, which is going to be detrimental. In such a situation, a person can file a caveat under Section 148A of Civil Procedure Code. So when a caveat is filed, the notices by registered post-acknowledgement due is served to the applicants, the possible applicant who is likely to file a case. Caveator will serve notices by RPAD to the caveatee. So then it becomes mandate in the court that without hearing the opposite party, ex parte order cannot be granted. So generally law is that without hearing the opposite party, without hearing the opponent, court will generally not grant an ex parte order until unless there is a substantial law that is involved, that mandates, that forces, when the court is convinced that ex parte order is necessary. Only then, in a rare situation, the court will grant an ex parte order. But when a caveat is filed, even that chances are clear. Court cannot grant an ex parte order without hearing the opponent. So therefore, when there is a doubt, when there is a possibility of an opponent who is likely to approach court for obtaining an ex parte order, in that situation, caveat is filed in order to nullify the act of the applicant to obtain ex parte order without the caveator being heard. So this will ensure the law is applied properly. See, when both the parties are heard, when there is a challenge, the opponent has to be heard by the court. The procedure, that is the due procedure of law, is that once a claim is made against another party, when a demand is made against another party, the another party has to be given an opportunity of being heard. So this caveat provides an opportunity of being heard before the court takes any interim